Good morning. I welcome everyone to the Justice Committee's 27th meeting in 2012. Can I ask everyone to switch off mobile phones and other electronic devices completely, as the interview of the broadcasting system, even when switched to silent. Apologies for this meeting have been received from David McCletchie. I welcome Sandra White to the meeting as our new member. You can tell us afterwards how you feel about it in private. Item 1, declaration of interest. Can I ask you, Sandra, if you have any interest relevant to the remit of this committee you wish to declare?
I have nothing to declare, Convener, but could I draw your attention to the fact that we have a number of petitions, and I was on the petitions committee at that particular time. So I would certainly draw that to note.
See that as an advantage to us. Item 2, decisions on taking business in private. Committee is invited to agree to consider item 4, 5, 6 and 7 in private. 4, 5, 6 and 7. Oh, I've got a 7 on here. It's 3, 4, 5 and 6 in private. 3 being considering of approach.
4, 5, 6 and 7, that agendas didn't include
So, wait, it's rewind. It's
4, 5, 6 and 7.
4, 5, 6 and 7 in private.
Yes.
7. What's
We added
7?
that.
Oh yes, thank you very much. Are we agreed?
No.
Right, what are we not agreed about?
Sorry, Convener. I think I've raised this at committee a couple of weeks ago, that I feel that actually taking, this is over half of the agenda for the Justice Committee today that we're proposing to take in private, and I just think a lot of more of it should take place in public. That allows the public to scrutinise and hold us accountable for the decisions we take in this committee, especially item number 4 on my agenda, which is the committee's work programme. I certainly, and my party...
Just correct you, there's a big mistake on this agenda. It's number 5 now, yeah.
Right, do you have an updated agenda?
Sitting right here, that's
Okay.
where I got my vote.
So item number 5 is the work programme. I certainly, my party doesn't have anything to hide in terms of our priorities for the Justice Committee going forward, and I would propose that certainly that item would be taken in public.
Okay, right, can I tell you what, in order that we can get through material, can I take that item on that particular one, whether or not we take the work programme in private, the debate in that, after we've taken the evidence, gone through the petitions and so on, just to get a move on? You happy?
As long as we take that debate in public, yes.
We will take the debate in
Yes.
public, not a
Yeah.
problem about that, so we'll just park that one and come back to it.
The other items are in private.
The other items are the other items 4 and I'm going to come. This is where I'm.
Better just, probably best just to read them. 4, 6 and 7.
4, 6 and 7 are agreed in private, so it's just the work programme.
Well, I mean,
4 is just an approach, 6 are considering a draft report, and 7 is considering a draft report.
I mean, as I explained, Convener, over half of today's agenda is being taken in private, and I think that is of concern to the committee and to the Parliament. If we want to debate the items one by one, then I'd be happy with that.
Well, all right, except I have to say that this just depends on what's in the agenda that day, frankly. Sometimes we take nothing in private. But I'm not going to open the debate just now. I'm going to park this whole thing. Yep.
I'm sorry, Convener, but I do object to the language that Jenny Marrow uses when she particularly said her party does not like to take things in private. I can assure you, as being a member of this Parliament since 1999, I certainly don't do things in private either, and I think the public should know. So I really object to the fact that you say your party.
Well,
Now, I'm not having this debate just now. We're going to continue with the agenda, and then we're going to have a debate at the end. But what we do and don't take in private, I'm happy to move on now to the petitions. I think that's where we are now. We have 5 petitions to consider today, and I think it's very important that petitions are given time in this Parliament. People make efforts to lodge them. Petition P1280 calls for an amendment to the Fatal Accidents and Sudden Deaths Inquiry Scotland Act 1976 to require a fatal accident inquiry to be held when a person from Scotland dies abroad. Since this petition was referred to us in September last year, we've been keen to establish exactly when the Scottish Government intends to legislate in relation to fatal accident inquiries. The latest response to the Government indicates it will legislate in FAIs during the second half of this parliamentary session. Now, can I have your comments on the next course of action for this petition, please? Just nominate yourselves, Rod.
Can I suggest that the petition remains open pending the introduction of the legislation?
Graham?
Could we also, I agree with that, could we also record the fact that It's unfortunate that the government haven't been able to give us a date, and that I've offered on a number of occasions to take forward a bill as a member, if that made it easier for government business. So it's really a matter of some import that we see this legislation coming through.
I think we're all wanting to see this matter accelerated across the committee. So we're keeping it open. And we're also on record that we wish the government to get a move on, as they would say. My mother used to say. Right. PE 1370 calls for an independent inquiry into the conviction of the Basit Ali Mohammed al-Megrahi for the bombing of the Pan Am Flight 103 in December 1988. Again, this petition was referred to since September last year. Since then, there have been a number of developments, not least publication of the SCCRC's statement of reasons on the case of Megrahi's death in May. The committee has also heard evidence from the petitioners in relation to the Criminal Cases Bill, which is now enacted, and considered recommendations from Lord Carloway and appeals in relation to SCCRC references. Again, the petitioners have helpfully provided further information in the annex to your papers. Before I ask members if they have any comments, I make a declaration. Before becoming Chair of Justice, I am in fact a member of the Justice for Megrahi campaign. Members. Graham.
It seems to me that we've had this statement of reasons from the Criminal Cases Review Commission, and that an appeal was activated at one stage and then placed in limbo. It was open to Megrahi to continue with that appeal. It's still, as I understand it, open to the relatives of Megrahi to see it forward, or perhaps one of the relatives of those affected by the Lockerbie disaster. And I wonder if that's a more effective way of seeing this thing forward, if that were to be the choice of those who are directly able to take forward an appeal process.
Thank you. Sandra, then Colin.
Thank you very much, Convener. Obviously, we declare an interest as this was forwarded to Petitions Committee when I was a member of the Petitions Committee. I think we all have to be very much aware that this particular issue is very much in the public interest, and I would certainly like to keep the petition open. I think the questions asked is whether an independent inquiry would be helpful or should be put forward, but certainly I would want to keep the petition open. I think it's very much in the public interest to do so.
Colin?
I'd echo the comments of Sandra White there, and just to say that it doesn't appear to be that much time since al-Megrahi passed away, and obviously it takes some time for legal ducks to be put in a row, and I would suggest keeping it open, keeping the petition open.
Rod.
Just touching on what other members have said, it is a comparatively short period of time since Megrahi has died. We have really no information as to what his family's intentions are in respect of a possible appeal. It seems to me that the proper course really is in the criminal courts until we are satisfied that no further criminal proceedings will be forthcoming. I think it would be inappropriate to support an inquiry, but that doesn't mean, I think, that the petition should be closed.
If you want, John.
If I may, thanks, Convener. I would agree with a lot of what's been said there. I certainly think in the additional information we have about the pressures that are placed on citizens within Libya and Mr al-Megrahi's family, as it says here, unlikely to be receiving encouragement to pursue an appeal. But I think a factor that we should bear in mind is the live, ongoing criminal investigation. I would favour the petition being kept open, I have to say.
I think, I may add something to this, is that as I understand it, and I think it's in our papers, that a letter has been sent to the Cabinet Secretary, this is in our papers, letter of complaint, lodging serious formal allegations relating to conduct of the investigation and the trial, and that has been given 30 days grace to be answered by the Cabinet Secretary, and then it will be public. I think we would like to see that and the Cabinet Secretary's response before we decide anything. I accept what is said about a court case being one way forward, but there's also, and I've raised this before, I just put this as a possibility. There is a possibility under the Inquiries Act for the government to conduct an inquiry into something wholly within its remit. Well, the operation of the police and the Crown offices and wholly within the remit of the Scottish Government. So I just put that in the record that there are certain powers that governments do have, whether or not they are used. But I would suggest, and can I take it then that in the light particularly of the letter, the fact that the SCCRC's the position is going to change, we think, under Carloway with regard to the gatekeeping of the High Court as a court of appeal, that we keep it open for the time being while all these things are in the air. You agreed? Yes. So we keep it open and continue it. Shall we continue this to a specific time till such time as we have the response, if any, from the Cabinet Secretary, together with the publication of that letter, and then we can reconsider the position?
Yes.
Thank you very much. We now move on to PE 1427, which is the first of our new petitions, calls for recommendations on multi-party actions by Lord Gilney Scottish Civil Courts Review to be introduced through changes to existing protocols. In correspondence to the Public Petitions Committee on the petition, the Scottish Government has indicated it agrees with Lord Gill's recommendations that a multi-party action procedure should be introduced and that it will bring forward legislation for this in the lifetime of this Parliament. This petition is the petitioner's attempt to allow multi-party actions to be introduced at an earlier date by existing means before legislation is enacted. The Government also suggests that the petitioners contribute to a consultation on taking forward many of the recommendations of the Civil Courts Review to be published later this year. You also have a copy of correspondence from the Lord President and a response from the petitioner to comments made by the Scottish Government and the Lord President. Do you have any comments, please, in the next course of action? Can you just tell me, indicate if you wish to make a comment? John.
I would favour option A, as is indicated.
Well, what's
there,
that?
Which is keeping the petition open pending the introduction of primary legislation.
The committee agreed. I see nobody else responding. Right, thank you. Petition 1436 calls for the retrospective abolition of the corroboration requirement. Lord Calloway has been recommended in his review of criminal law and practice that corroboration be abolished. The Scottish Government intends to bring forward legislation on Lord Calloway's recommendations next year. Have we got that? You have a further submission, I think, from the petitioner. I don't know if you have had the opportunity to read it. I know, I have to say to the committee, you know, I know you've got loads of papers and we shall try to get them out earlier to you because there is a lot of reading to do, hours and hours of it. And I put it on the record, it's a very hard-working committee. Have you had the opportunity to? Right, it was submitted in good time advised, but there were legal issues that had to be resolved before you could get it. So I'm not by any means blaming our system here. Do you have any comments on the next course of action for this petition, please?
It seems to me we'll have a debate this afternoon which may have some additional information that will have a bearing on this. It's difficult to make a decision at this stage.
It's open to members, obviously, to trail this during debate. I have huge problems about retrospective anything, but I think that... shall we just leave it open just now?
Please.
Thank you very much. PE 1449 calls for an independent Scottish Administrative Justice Council to be preserved after the abolition of the Administrative Justice and Tribunals Council and with it the Tribunals Scottish Committee. The Minister for Community Safety and Legal Affairs copied the committee into correspondence on 4 September in which she outlined her intention to set up a non-statutory advisory committee to carry out many of the functions of the Scottish Committee after abolition. We also learned from the AJTC's, I can't tell you how happy I am to use just the letters, Scottish Committee during our consideration of the Scottish Civil Justice Council Bill regarding the possibility that it may take on administrative justice functions at a later stage. Again, the petitioners have provided further information. Do you have any comments?
Yeah, thank you. There are a number of options, but certainly the option that I would propose would be to close the petition on the basis that since the petition was lodged, the Minister has outlined new proposals for a non-statutory advisory committee and is also considering longer-term options. And I'm sure Mr Hinton, the petitioner, could feed into that.
Rod?
I'm not sure I entirely agree with Sandra. I thought we could ask for a few more details of what is actually going to be involved in the non-statutory advisory committee, a timetable and general further information of the government, although I appreciate that this is a moving feast and they're in some respects responding to events from another place.
I think, Convener, Rod's quite right that I was left with the impression that we weren't on solid ground yet in terms of what the future might look like. and therefore it might be too soon to take a decision that we would want to close this matter.
Leave it open?
Yes.
And anything else?
I'll bow to the superior knowledge of the...
You bow to the superior
members.
knowledge. Don't grow his part. Yes.
I think we could ask the Scottish Government for some further details as and when they're in a position to produce them, but I suspect they'd probably say that they can't give us very much at the moment, but
Certainly good to leave it open till the
yeah.
introduction of the bill, the tribunal's bill.
Happy
well.
to do that. Happy to do that, and also encourage the petitioners to submit to the consultation and throughout it, actually, even at stage one, with any comments after we get to that at stage one. Right, we now move on to this discussion, which would be when I asked if we were agreed, if we would, I've lost my place again, taking business in private. We're back to item 2. Jenny.
As I explained, convener, at the start of the meeting, I just feel that over half of today's business has been taken in private, and I have raised with the committee before my unease with the work programme being taken in private, because I certainly feel that there's nothing that I would want to see in the Justice Committee considering going forward that needs to be discussed in private. I'm happy to discuss our priorities and to clarify what I meant when Sandra White picked me up on my party. I meant our priorities going forward for the committee and what the committee should be looking at. I certainly don't have anything private, and it should be open to scrutiny by the public, and that's why I especially propose that item number 5, I think it now is, should be taken in public.
So before we move on, are you happy then that we do as we have is standard practice actually in it's been standard practice actually to do work programme as well as stage reports and discussion about likely witnesses and approaches in private for 13 years. Are you happy that we at least do, we can say that 6, which is a draft report, 7, which is a stage 1 report, and an approach to something that's 4, 6 and 7 are in private?
Convener, I'm sorry, I'm mixed up with the,
Well, there we are.
number. Have you got a new agenda? That would be useful.
That's that one, which is the approach. That's a stage, that's a draft report, and that's a draft report.
Well,
So if we narrow it down to the work programme.
I thought your proposal was to take them one by one, and
Well, I'm just trying to move on. We've got a lot of work to do. So if you're not really, if these are not matters you wish to debate, then we can tick off 4, 6 and 7 and just talk about the work programme, whether or not that, in principle, should be discussed in public.
I'd be happier if we stuck with your original proposal to discuss them one by one.
Right. Well, why should we, my question is, why should we discuss an approach to a memorandum in public?
I suppose you need to turn the question the other way about. There's an actual presumption that we would always discuss things
Well, we
in
have
public.
for 13 years.
Yeah, why would we discuss them in private?
I think every parliamentarian wants the elected to see the work they're doing. So presumably if this long-standing convention's in place, there's a reason for it. And without putting the clerk on the spot, but just about to put the clerk on the spot, I wonder if it would be possible to outline the rationale behind the decision to take individual items in private, because I'm certainly supportive of us doing as much as possible in public, but certainly it may fetter when we're discussing individual witnesses. And
I think each case must be taken in its merits. Excuse me, and obviously it's a decision entirely for the committee in each case. I think you're right to identify a main reason as being the fact that in discussing an item of work, you may be potential future work, you may be discussing potential future witnesses, and it may be considered more appropriate to do that in private. But in each case, it would depend upon the circumstances of the item being considered.
I have to say, I'm a very open member of Parliament, always have been. And you know, I take the government on all kinds of occasions. I may even do it this afternoon, probably will. I think for me, the issue is freedom of members to openly discuss with other members and sometimes say silly things and inappropriate things, as they may do, or maybe I shouldn't have said that in public, when they're discussing whether or not we take on certain issues and how we approach things. It also means that you can actually, you know, if you were to try and record it in the OR, it's messy. I mean, you have people jumping in. It's a very free conversation. It's not like evidence taking. you know, or any of the other things we do where we try to have a coherence, even though we have differences. We have to coherence to our questioning. So just in terms of efficient working of the committee, I have to say there's not a single, for me, sinister thing in any of us doing any of those particular things. And it just so happens today that there are 4, 2 of which staged reports we've always done because it allows, again, free discussion, amendment. And, you know, when I think of a stage 1 report, when we're going to be sitting, going over the stage 1 report, maybe taking the odd word out and people fight over an adverb, it can look awful daft to the world outside and, you know, go to the wire over a conjunction or something or a semicolon. And that's what we sometimes get down to. But that's free discussion. And that allows members to relax and be honest and then not be looking foolish sometimes. The work programme, and I'm just going to say this, we've had a long time in here, and I've also been members of committees for this, and I've never ever objected to any of this when I've had conveners of any other hue sitting in the chair. The work programme, again, sometimes people, you know, you go through and you, for a reason that you're not going to take somebody on, either we've got too much on our plate, or, well, we think that they didn't make a reasonable case for it against somebody else. That can be quite hard for people who've taken the trouble to write to the committee to ask to do. And, you know, in fairness to committee members, as well as the people, we have freedom to sift through. And as you know, we come to our work programme, Jenny, collectively. I mean, that's the other thing I have to say about this committee. We have come to things collectively and in goodwill, even though we have quite often different views. And I'm rather sad, frankly, to see this come up as a contentious matter, because to me, it's wholly unnecessary, and has been wholly unnecessary in my 13 years in here. I think conveners across the committees have operated like this for as long as I can remember. And it's not, and today it just happens to be one day when it's like that. Other days we'll have nothing in private. I've said my bit, I'll let others come in. It's just, I think it's a bit of a red herring.
You know, again,
Graham,
again, Peter might be able to help us. The likes of item 4 there, the prisons bill. Is it feasible that we could have a discussion about the approach, and when we enter that element of the committee decides we want to take evidence, we can go into a private session then to discuss witnesses, but at least we could have the logic of the debate on the public record? Because it looks a kind of sinister thing sitting on... Wait a minute, let me finish.
No,
it looks a sinister thing in the headline, but in actual fact it's fairly mundane and practical.
I'm agreeing with you, but I think we'd have to have, Peter, was it a separate item in the agenda, selection of witnesses? I mean, that's fine, that's not a problem.
But that would only be if we decide... We might decide once we discuss this, no, we're happy, let it flow through, we don't need to do any more with it. Or again, we want to talk about witnesses.
I'd be very unhappy about discussion of witnesses being in public.
At that stage.
And also stages of debates in public. I'd be very unhappy, because I think that we do come, I think we've come to, you know, pretty well unanimous, and we've managed to get a form of words that we could sign up to, and sometimes that's not been easy, but folk have been prepared to give and take a bit. I don't know if they'd be prepared to give and take a bit if it was in public, and that worries me about the operation of this committee, which is very successful.
Can I say on that, that's the discussion of our report. I think suggestion Graham makes for item number 4 on prisons, we're more considering our approach to the bill. We're not discussing a report at that stage, and then to move into private for the selection of witnesses would seem to me a reasonable.
That's fine. So we've agreed that we are not unhappy. Did the committee say that for item 4, our approach to the legislative consent memorandum we will hear in public? Yeah. We'll not discuss witnesses. Right. So we've done that. But I moved on because you wanted to take them all, you see. That's why I've taken the stages. I would like you to now consider what I've said about stage reports, draft reports and stage 1 reports, whether we continue to do these in private for the reasons that I've given.
Again, see, if I remember last year properly, if there's an element where any member of the committee feels very strongly about a report, they can have a part put in. So where we fall out about something, we can record that fallout, even though we're discussing it in private. And we can achieve, you know, if there is a feeling that because of the way the committee operates, we're not ventilating matters properly, then we can stand on our principle and insist that we get a paragraph put in the report, even though it might be a minority view.
Never ever
That seems
stopped
to be,
that.
that was my memory from last
Yeah.
week, last year. Not that it was very often that we
This
needed to
is-
do that.
It's my 4th time as a convener. I've never ever stopped anyone expressing a view. What I've tried, first of all, to get consensus and wording we can stand up. And sometimes it's not possible. And if it's not possible, so be it. And it's perfectly right that someone should be entitled to express a different view.
The issue that Jenny raises about, the secrecy, it appears secret because we're not discussing it in public, is something that we need to be careful of. That, we demonstrate that we only do it when we absolutely have to, but we can still publicly record our views. So I think it's a reasonable issue that we should discuss and then hopefully come to some sensible outcome.
Colin.
I have a slightly different take on this. I find that the private sessions are very handy because at least the substantive debate is there and we know what the ground rules are when we go into that debate, whether we agree or we don't agree. But that's only there, and we've avoided the party political bun fights to a certain extent because we've sat down and we've agreed the process beforehand. And I'd be quite concerned, to be perfectly honest, that what happens is we end up with something in public, something in private, then heading back for a substantive debate, and it all looks that wee bit messy. That would be my real problem with that. And I think the work programme, if I may say something on that, we've got a heavy bit of work, as we've seen over the past 18 months or so. It's going to be very heavy in the coming months as well. And I find it looks as if something in public there that somebody says, well, I don't think we should be taking that at this time. It's almost like all that work's been done by these people outside. It's looking as if the committee or that individual is devaluing their bit of work that's going in. We at least produce a line of work heading forwards that we're all agreed on. The ground rules are there, and we can then get into the substantive debate quicker.
Sandra.
I'll try to do quick. I think everyone agrees, and certainly agree with Graham and Jenny and yourself, regarding the witness situation. That's got to be absolutely private. I don't think it's helpful when you talk about secrecy, because it's not secrecy, it's protecting everyone. I have concerns that I'm not a lawyer, so obviously when I read the paper, I don't know the legislative or the lawyers speak. I'm quite worried from my own personal self that I may step over the mark if basically everything is in public in that respect. And I think the clerks would need to, if we're going to do that, keep us absolutely right, because obviously the legal situation. So I think it's something that seriously needs to be looked at. But I think the clerks would need to be able to produce a paper to make me comfortable with certain things, perhaps being in public.
I think I've said what I've had to say. I mean, from my experience of this, as I say, 4th time, I hope I know something about convening now. The good running of a committee, the goodwill of a committee is terribly important. Political posturing is the death knell to a committee. People having arguments over a stage report, over some, at the end of the day, it might be quite a small thing in public, is bad for a committee. I mean, our duty is to try to work together, notwithstanding some political differences at times, and to be coherent and to come up, particularly with government legislation, and to put the government to the test. And indeed, in inquiries, I think we've not had the really opportunity to do that. It's much easier, and therefore I have seen this working well. And if it ain't broke, don't fix it, I have to say to Jenny. And I understand it looks like that in paper, but it happens to be this time. There'll be weeks when there's nothing in private. And that's the way it swings and roundabouts. And as I say, for the reasons that others have aired, especially discussing the work programme, we have good reason for not doing certain things. And people are written to if we decide not to take something up. We do write a letter explaining why we've been unable to take the particular matter up. It's not that they're not informed, but it's done in a form, a proper manner. Rod.
I don't want to reiterate what people have already said, but just in relation to the work programme, I think there is something to be said for the fact that we could speak freely about competing priorities between different things. And if we have to think, oh, this is all going to be in public, perhaps I should be very careful what I say here. I think that would be to the disadvantage, generally.
Well, I'm there we are, and where do we go? I'm asking now if the committee, I'll go through them one at a time.
Can I come back
Yes,
quickly
of
on
course,
the
yes.
work programme? Because I apologise, I feel the work programme is the one I feel most strongly about, and I understand what colleagues are saying about the free discussion, but I feel we're elected here and we must have broad shoulders and we must be able to justify the priorities that this committee takes, and we must be able to do that in public and justify it to the public as well. And politics is all a matter of competing priorities, and we're always going to have that. But the more we push into private, our priorities, discussions of those priorities, the less transparent we are for the public.
Right, we've heard that. I'm now going to go through the items one at a time. Item 4 on the agenda, which is just its approach to legislative consent memorandum. Are we taking this in public or private? Could I just see who said private?
There's the prisons.
This is number 4. We're back. I've removed your. I didn't. 4. Right. We can take it in public and not discuss witnesses. Would we agree to that? Yes. Right. Item 5, work programme. Public or private?
Public.
Well, the majority have said private. I will note that the 2 members...
Just call a division formally.
I'll call a formal division. Those in favour of being done in public, please show. Those against, please show. And it's regrettable that other members aren't there. I think, is it proper to ask the other members who are unable to come, they can't make a view in this now?
You can express a view, but that's...
I think we'll ask them, because we've now taken a vote, and it's unfortunate, but there we are, because I'd like the other members to express their view on whether it should be public or private. Now, the next one is the draft report on the defamation bill number 6. Do I have members' agreement to take this in private? And the stage 1 report in private. Thank you very much. Right, now let's move on. And what am I on now? Because I've got this thing, I've lost my place. So, I'm looking for my bloody script. I'll switch the microphone. Thank you very much. Now, thank you. That was a tactical switching off. But it wasn't anything in private. I was just mumbling to myself. Everything sinister was going on. Item 4, we move to paper 6, and we're asked to consider our approach to the legislative consent memorandum, the prison's interference with wireless telegraphy bill. The aim of the bill is to authorise interference, in quotes, with mobile phone signals in Scottish prison and young offenders institutions. There are some options on page 3 of the paper, and I understand there'll be time to hear from the Cabinet Secretary perhaps on 30th October after he's given evidence on the budget, and to seek some written evidence in the meantime if members are keen to do this. Can I have members' comments, please? John.
Yeah, on page 1, paragraph 3, I would like some clarification about what would be considered to be disproportionate interference, because as far as I'm concerned, I mean, absolutely see the need, but the implications for out with the walls, if you like, for the emergency services, I want some clarification. I also thought the phrase protection of health and morals was quite a fascinating one.
I think I'm in need of that.
Yeah. And further on, with regard to the annex, just to note my surprise that whilst it was a criminal offence for all the other participants in provision of communication equipment, it was simply a disciplinary offence for a prisoner, and I thought that was peculiar. Also, in relation to 2 other points, if I may,
please, yes.
Paragraph 15, I was surprised that there hadn't been a form of consultation at UK level. And in relation to 16, I thought there was a contradictory statement where it said the bill will impose no financial obligations in the public sector. And then it goes on in the final sentence of the same paragraph to say there will be financial costs in the procurement of signal interference equipment. So I thought there was a contradiction there.
No, fine. I'll take Graham then. No, please. Graham.
Sure.
Such friendliness.
The bit that, and I agree with the points that John has made there. It'd be good to get some clarification in these points. The bit that wasn't clear to me, having read the papers, and hopefully I haven't missed it, is who oversees these arrangements in terms of appeals and ensuring that the processes are properly adhered to. In other circumstances, there are forms of inspectorate who come in annually to check that this kind of power is operated appropriately and in the spirit of the legislation. I don't see any mention of that in here. Hopefully we would be able to get some information on how that would operate.
Sandra.
I entirely agree with John and Graham also. One of the areas where John has already raised about the proportionate interference, but it was actually item 4, paragraph 4 on page 1, providing for the detention and disclosure of information obtained through interference and required that this information must be destroyed after 3 months. Quite concerned about that particular one, and I think we would need to write to the various operators to get their views on that. My concerns is, where is the information gained from? Is it just from emergency services, or is it from houses and people round about? These are kind of questions I'd like answers to. Perhaps I'm jumping the gun a wee bit here, but I think to get answers to this, we would need to write to the various operators and also hear from the Justice Secretary, because I do have concerns about paragraph 3 and paragraph 4.
I think what would be useful is, obviously with relation to whether we decide or not to take any evidence, perhaps the process first would be for a draft letter to be circulated raising all these points, which we send first to the Cabinet Secretary. And then we will consider next week, perhaps if we could have some kind of response. Do we want to do that? See if we've got a response from them first, or just go next week discuss witnesses?
Discussing later, I think it's not that much. It's leading from the 30th, according to invite witnesses for this.
Yeah, I'm mindful of the timetable, so I think next week we'll discuss possible witnesses. Our letter will be out to the Cabinet Secretary alerting him. I think in any event we'd want to hear from the Cabinet Secretary on the 30th of October when he's here anyway. Is that all right?
Yes.
Give him advance notice. And in the meantime, we can discuss next week very interesting points that are raised, also ECHR issues, certainly with regard to this surveillance, if I may call it. Right, we move on to item 5, which is our work programme, and we're now moving into private session. So wait for the room to be cleared.